Are you worried about your ideas being stolen? Here are some simple steps to prevent that from happening. Step 1, document everything. If you're developing a new product, a new process, you're starting a company, you want to make sure that you're creating a record in like a lab notebook, notes that you just keep. You want to date things. In the instance in which the dates in which you came up with stuff is being challenged, you can say, look, I keep this notebook, I keep this chart, I keep this calendar. It can help bolster your argument that actually, hey, I came up with this thing first. Second step, use non-disclosure agreements. You want to make sure that when you say, hey, I've got this new product line, here's how that product works, or I've got this process, here's the steps in that process. You want to have open conversations, but you want them under non-disclosure so that they don't walk out the door after your meeting and can disclose it to the world. So use non-disclosure agreements early and often, especially when you're talking to third parties, and especially when you're talking about sort of new stuff, either it's a new product line or development, a new plan of action for your company. Step 3, consider provisional patents. So a provisional patent application never gets examined, never issues as a patent, and it's not actually enforceable against third parties. So you're probably thinking to yourself, why would I ever get this? One is it gets you a filing date with the U.S. Patent and Trademark Office. And a filing date means that someone else won't be able to beat you to the patent office first. You file a provisional today, you tell someone tomorrow your invention, they can't then beat you to the patent office by filing a patent the day after that. The second reason is that it's also a cheaper way of getting patent protection. They're less costly to file. And then the third reason, you can have patent pending. You can say, look, here's my new product line, here's my new design. It's a patent pending design, and it's a great way to put the world on notice that, hey, this is actually something that could turn into a patent. So you might not want to spend the R&D money required to develop a product that potentially infringes something I've already got a patent application on. It's a real inhibitor to those competitors to create that competing product. Step number 4, register your copyrights. Unlike a patent, in copyrights, you get them as soon as you create them. So you write a book, you play some music, you take a picture, regardless of whether or not you showed someone else, regardless of whether or not it's published, upon creation you get those copyrights. You're like, Tim, why should I get a copyright registration? There's a couple reasons. One is that whether you want to license it or sell it, if you ever want to assert against a third party, it's a necessity, because then you can reference the copyright registration in a license agreement. Copyrights come with a big stick for enforcement purposes. Statutory damages are available. Those are sort of per infringement. The damages themselves may be 10 times more than the infringer actually made from the profits of selling that infringing product. So it's a really big stick for very low cost, because registration from the Copyright Office is one of the cheapest there is as far as filing fees go for any type of intellectual property. Step number 5, keep your trade secrets safe. And it may seem very straightforward, but in order for a trade secret to be considered a trade secret, you actually need to keep it secret. You're talking, a process, can be an invention, it can be formulas, business practices, designs, can even be client lists, it can be customer lists. So making sure that you're controlling who knows those trade secrets, that if you tell third parties about those trade secrets, that they sign non-disclosure agreements. Even your employees who are on need-to-know basis with those trade secrets have confidentiality agreements with the company. The biggest defense to a trade secret claim is that the thing that the company says is a trade secret actually in fact is not a trade secret because it's well known, or they didn't protect it, or they didn't have confidentiality agreements with third parties. So making sure that you keep the trade secret secret is really what's pivotal for making sure that that important bucket of intellectual property is protected as a company. And the last step, avoid public disclosure before protection. This advice is really just forward thinking. It's about saying, hey, I've got this new product, I've got a design, I've got a formula, I've got this new invention. You want to make sure that you've just at least gone through that mental checklist of, is there protection for this type of intellectual property? Are there multiple ways to protect this that need to be done to make sure that other parties aren't using it? We're sure that it can be protected as a trade secret, that we're going to have non-disclosures. If it's an invention that you want to patent, you want to go down the patent route and file a provisional patent application. Or that it's a work of authorship, it's absolutely something that we want to protect through copyright registration. Having a plan will make it a lot easier down the road to protect that intellectual property and be profitable. Keep in mind, none of these steps are foolproof. The more that you can do to protect yourself on the front end when it comes to intellectual property, the more options you're going to have on the back end to sort of enforce it and make sure that other folks sort of aren't using your ideas or stealing them from you. Catch you next time.